Well, welcome everyone. My name is Doug Surtees, and I'm the Associate Dean Academic here at the College of Law. And I'd like to bring greetings to all of you from our Dean, Sanjeev Anand, who was called out of town on business today. I'd like to welcome each of you to our conference and our beautiful new portion of our law school that we're so proud of here. And I just wanted to reflect on our motto for a minute. Our motto at the college is Fiat Justea, or let justice be done. And I thought it was appropriate to mention that at the beginning of this conference, because certainly if justice is going to be done, it's important that those who work in the justice system, those who study the law and teach the law, reflect the people that live in our community. And if there's barriers to that reflection, then it's appropriate that we examine what those barriers are. And if working in the justice system causes harm to people as they study, teach, or practice law, then it's appropriate that we look at why that harm is caused and try to work solutions out to it. So I think this conference is an important step in continuing some of that work, and I welcome all of you and hope you enjoy your next day and a half in our beautiful College of Law here. I'd like to turn the meeting over to my colleague, Wanda Wiegers, who's been the principal organizer behind the college today. So please, welcome Wanda.
Hello. On behalf of the organizing committee, which is comprised also of Professor Marilyn Poitras, Madam Justice Georgina Jackson, and Sarah Trefiak, who is our communications officer, I want to extend a warm welcome to all of you and thank you for making the effort to be here. For me personally, it's particularly a pleasure to see those of you who've been my students during my tenure at the college. The main objective of this conference is to address in a meaningful way how we as lawyers can achieve equality, emotional well-being, and social change in and through our work. First, we plan to explore recent and potential changes in the context in which lawyers today are working. Over the past 2 to 3 decades, we've witnessed an influx of women, Aboriginal and racialized persons, and people with disabilities and differing sexual orientations into legal education and practice. At the same time, we've seen in some jurisdictions a substantial increase in the size and number of large law firms, with a greater emphasis on billable hours, as well as talk of other changes that will allegedly bring about, quote, the end of lawyers, at least as we know them. Foreseeable changes include more competency testing, greater use of online resources, offshore outsourcing and external ownership of law firms, and in general, more competition both between lawyers and related professions. These alleged trends are or will be occurring in the context of, and perhaps to some extent in response to, what some describe as a crisis in access to justice and a serious lack of affordable legal services. In this conference, we hope to reflect on the changes that are in fact affecting your lives as law students, legal professionals, and members of the judiciary, and address as well whether these changes are likely to be experienced differently by diverse groups within the profession. In the small discussion groups that follow today's panel, we'd like to know what issues concern you, what your aspirations are and were when you entered the field of law, what you find most fulfilling and challenging about your law-related work, what changes, if any, you are experiencing or expect to experience, and what changes will have the greatest impact on your well-being and that of your clients. We also intend to explore the business model of private practice and its impact on work-life balance, the retention of lawyers, particularly women lawyers, and access to justice. So we have speakers who will address what is currently known about the status of male and female lawyers in Saskatchewan, the costs and benefits of achieving work-life balance, the impact of innovative strategies pursued in Ontario to accommodate work-life balance, and ways in which law firms can be restructured to enhance both access to justice by clients and lawyer satisfaction. We all know that the work that lawyers do can be highly stressful, so a further issue we wanted to examine is how lawyers can most effectively deal with or manage the emotional effects of their work, such as the impact on them of client trauma, or the impact of conflict or incivility between lawyers or in relation to other actors within the justice system. In the small discussion groups tomorrow, following the 2 morning panels, we again will ask you to reflect on what has been most meaningful to you about your work, what has held you back or made it more difficult to realize your aspirations, how you've dealt with client trauma or other emotional stressors, and what can be changed to enhance both your own happiness and your effectiveness as a lawyer. Finally, for those who came to the law with the hope of making a difference and were motivated by an aspiration towards social justice, we hope to begin to explore how we can most effectively make such a difference and how we can create or make the most of the opportunities available to us. To that end, we've invited speakers to comment on the pursuit of social change through their involvement in law and politics, and in law and social movements, as well as speakers who can address law and social justice initiatives in various legal contexts. We believe we put together a brilliant lineup of speakers, people who have devoted much of their lives to thinking about and addressing these issues, and who can be counted on to stimulate reflection and lively debate. In particular, I would encourage you all to attend the dinner and speech this evening by the Honorable Marie Deschamps, who will address changes occurring within the judiciary. We've structured this conference to allow both for speeches and panel discussions and 2 sessions involving small group discussion. Please note that these plenary sessions are being videotaped and are being streamed live to a room in the college where students can observe the proceedings free of charge. Now, the small group sessions will consist of about 8 to 10 people who will discuss the issues raised and canvassed by the panelists, as well as issues that you yourselves want to bring to the table. In your packet of materials, you should have received notice of your assignment to a particular group. So these groups were generally arranged at random, but also with an eye to achieving gender and professional balance, etc. If for some reason your name does not appear on any small group, please contact either me or Sarah Trefiak, and we will add your name. Now, in each group, the group leader or another group member will take note of comments that are made during the session, but will do so without attributing those comments to any identifiable person. And subject to the consent of the speakers, a video recording of the plenary sessions and a summary of the discussions among small groups will be placed on the college website after the conference. We've unfortunately had a few last-minute cancellations in our list of speakers, but you should note that sticking to the schedule will still be very important, especially tomorrow, where the lineup of speakers and sessions remains very tight. As for food, a continental breakfast will be available tomorrow morning at 7:45 a.m., as well as lunch. Coffee and snacks will also be available outside this room, both today and tomorrow. There are cocktails and dinner this evening in the Exeter room at Marcus Hall. That's the 2nd floor, as per the map that's in your package of materials. And that will begin at 5 p.m. For those of you who have food allergies, there should be, I think, several options available. Tomorrow, we will close with drinks or cocktails in the late afternoon in the student lounge. Note there are 5 tickets in your package, 3 blue ones. These are drink tickets for the banquet tonight, and 2 red ones for the reception tomorrow. So if at any point you have any questions or concerns about the proceedings, please contact either me or Sarah Trefiak, and we'll do our best to resolve them. Our thanks go out to the Law Foundation of Saskatchewan for making this event possible through its generous funding. And our hope is that, in the words of one of my co-organizers this morning, we will have fun and learn a lot. So I'd like now to pass the mic over to Professor Beth Bilson, who's going to chair the first panel.
Hello, I'd like to add my greetings to those of Doug and Wanda. Welcome to the College of Law at the University of Saskatchewan, at least to those of you who don't spend all your time here already. I am very pleased to be chairing the first panel this afternoon, which is on the topic, the changing face of legal practice and legal education. And I think you will agree that we have a distinguished lineup of speakers to address some aspects of those topics, which of course are very, very current and very pressing topics, I think, for the legal profession and for people in the legal academy. The speakers who are on the panel this afternoon, the first speaker will be Professor Susan Boyd, who's a member of the faculty at the University of British Columbia and is an expert on family law and women's issues. Our second speaker will be Tom Schonhofer, who's the director of the Law Society of Saskatchewan, and the focus of his interest is the changes that are taking place in the legal profession and the challenges that are facing regulators of the legal profession. Michelle Hollins, who is a graduate of this law school, is a partner in the Calgary firm of Dunphy Best Bloxham, and next year will be the president of the Canadian Bar Association. And Michelle is going to talk about some of the issues related to the leadership of women in law firms. Catherine Hensel is a barrister from Toronto who practices in the area of Aboriginal law, and she is going to talk about some of the challenges related to advocating for Aboriginal people in the justice system. So I hope you'll welcome our speakers. The format for this afternoon's panel is each of the speakers will comment on their topic, and then there will be plenty of time for questions and comments at the end. So I'll ask Susan Boyd to begin.
Good afternoon, everyone. I'm really honored to be on the opening panel for this conference, and I thank Wanda and her organizing committee for inviting me and for also bringing us all together. So many things have changed since I entered law school at McGill in 1975. As somewhat of an outsider, there were no lawyers in my family. I was from a small rural community, and I think it came as quite a surprise to my mother that after doing my BA, I ended up choosing law school. In one of the workshops, maybe we'll talk about those quote-unquote choices. In my first year class at McGill in 1975, women made up, I think, about 30% of the entry class. And the admissions committee at McGill that year apparently felt that they'd been quite radical in admitting us. And in general, I think they thought our class was a little bit different. For example, there was one man in our class who I believe was in his early 60s. And, you know, they thought they'd shaken up admissions that year a little bit. So things have changed. As you now know, women make up about 50% of students in the entry classes in most Canadian law schools. And in some cases, they actually make up more than 50%. In other cases, less, but in around that ballpark halfway mark. As well, in some law schools, women constitute about 50% of the tenure stream professoriate. And this is really a huge change since I joined, for example, UBC law in 1992. We've not done so well, at least at my law school, in terms of ethnic diversity or appointing Indigenous faculty members, but here too there has been some noted improvement. I'm going to mostly be talking about the feminization of legal education, though, and I want to first make the point that the feminization is not the result, I'm pretty sure, of affirmative action, but rather to three factors: the increased acceptability of law as a profession for women compared to, say, engineering, which I think still has some issues. Secondly, the removal of formal and informal barriers to women being admitted to law school. And thirdly, women's strong academic records. I think as law schools move to a more kind of marks-based, LSAT kind of based admission system, that actually probably ended up benefiting women in terms of admissions. So in terms of numbers, legal education has definitely been feminized in that there are more women entering law school, and as a result, more women are, of course, entering the legal profession. I'm going to leave it, I think, to my co-panelists to speak more to the issues in the profession. But what I really want to ask in my minutes I have with you is how fundamental are the numerical changes that I've identified? In other words, does the numerical equality that I think we are now experiencing perhaps divert inquiry from the quality of legal education for women and for other historically disadvantaged groups? I want to ask what happens when we shift the lens to examine the impact of feminism on legal education. And I'm going to try to capture in a real small nutshell what I think feminist inquiry has done in relation to law. I think that feminist work on law has not only looked at women's inequalities under the law and tried to remedy them or suggest remedies, but I think that feminist inquiry has also really challenged the way we think about law, legal knowledge. For example, a lot of feminists have emphasized the need to rethink legal categories. And also doctrines, legal doctrines that have both contributed to systemic inequalities and also sometimes made it difficult to redress these inequalities. I think feminism also has made us think differently about the skills that are needed for legal practice. And to think more broadly about that. And I just read on my way here yesterday an article by your own Sarah Buehler on clinical legal education and skills, which I think really encapsulates those sorts of ideas. So I now want to look a little bit at the curriculum in Canadian law schools and ask to what extent feminism has had an impact there. So again, looking back to McGill Law School in the mid-1970s, when I was there were no courses on women in the law, no courses on racism in the law, no perspectives on law courses, and really very few discussions of law in its wider social, economic, and political context. And I remember being quite shocked by that because I'd had an undergraduate experience in history and sociology, and I was used to asking some questions that I just found were not really asked very much in law school at that time. My major source of excitement in first year was actually a course called Foundations of Canadian Law, which included a section on Aboriginal title, and that's probably the thing that stands up for me most in my first year law experience, other than being terrorized in contracts by Professor Philip Slayton, who used a really strict Socratic method, the facts please, Miss Boyd, finding me in the middle back of the classroom. Anyway. By the time I became a law professor in the mid-1980s, things were definitely changing. Law and context courses of various sorts were springing up, as were, of course, courses on women in the law. Indeed, I was eventually recruited to UBC Law in 1992 to fill an endowed chair in women in the law, to which the legal profession had definitely contributed lots of funds. And I was encouraged to develop a course on feminism and law. But I know that I was also recruited for my ability to teach family law, a so-called bread and butter course. And this is going to become a bit of a theme in my talk, I think. It was and is, I think, unusual for feminist legal scholars to be appointed at law schools for their expertise on feminism and law, just as I think it's still unusual for legal scholars to be appointed for, say, their expertise in racism and law. These may very well be value-added types of expertise, but they generally accompany expertise in that faculty member in another field that is typically viewed and valued as core, as more important in the law school curriculum. So fields like corporate law, tax, of course, most of the first-year courses, torts, contracts, etc. And I think that particularly since the Federation of Law Societies has introduced its new minimum competency requirements with a corresponding impact in law schools on what courses are made mandatory, I think that law schools are feeling at least as much and possibly more pressure to hire faculty members who are able to cover those so-called core areas. UBC Law still has an endowed chair in feminist legal studies, and I still hold that chair. But I've had more than one colleague ask me whether I think that teaching feminist legal studies is even relevant in this post-feminist era. When I first arrived at UBC, it was pretty clear that some of my colleagues who were already there were relieved that I had been added to faculty, because that meant that I would teach feminism, and that meant that they did not have to try to integrate feminist perspectives into their own courses and their own teaching. So they were kind of like glad that someone else was going to take care of all that. In other words, the core did not have to be altered. And yet, of course, we all know, and I'll come back to this, most law students do not take things like feminism and the law. So anyway, it was kind of a curious thing. So that's a little bit of negativity. I do want to say some positive things, because there's no question that we've seen a lot of changes over the last 20 years or so. Our director of admissions at UBC Law says that our strength there in feminist legal studies and also social justice attracts quite a few students every year. So when they go out on their recruitment campaigns, they actually have quite a number of students saying, I'm interested in coming to your school because you have a focus on social justice, because you have a Center for Feminist Legal Studies. Our Center for Feminist Legal Studies, which has existed since 1997, does provide a focal point for students who are interested in a range of social justice issues. And we organize quite a few events and programs that I think are important, perhaps to many of the issues we're going to talk about over the next day or so. For example, the students organize a mentorship program between feminists who are in the legal profession or who have taken their legal skills into other realms, and law students. And this is on my mind because they just had their social event 2 nights ago at the law school. And I think, despite my little critique of the core, the focus on the core in legal education, of course it is positive that feminist legal scholars are teaching some of our core courses, because that is what most students take, and it does mean they're at least being exposed to feminists in the classroom, raising possibly some different issues. But I still think we're seeing a lot of ongoing challenges to integrating feminism into the law school experience. And the analysis that I'm going to offer you now draws on what I think is some excellent work that has been done on the pressures on modern universities generally, not just law schools, but of course I'm going to focus on law schools in my comments. These pressures have been generated due to decreased government funding over the last couple of decades, so it's very clear that government funding to universities has been going steadily down. And as a result, what we have seen is something which a lot of people call the corporatization of university education. My colleague and partner, Claire Young, did a talk a few years ago in which she called this new system the Air Canada model of legal education. And she was alluding here to the first privatization and then restructuring that Air Canada went through a few years ago. In which they basically had less government money and had to do things like eliminate less profitable routes. As she explained, as government monies have declined to law schools, the new expectation is that we will secure private funds to support legal research and law teaching. Also, probably one of the other consequences is that we will eliminate our less profitable courses, and I'll come back to that. Professor Young talked about the fact that law schools must reposition themselves in this modern era to provide a simplified product offering its customers or its consumers, those being students and law firms primarily, what they want. Now, under these pressures, law schools must come up with what you might call business plans. We tend to call them academic plans in the law school. And we must measure the quality of our work by our outputs. So you can see that there's a sort of business language coming in here. What are our outputs? Well, they're things like how many of our students get jobs, what kind of jobs, how many get clerkships with the Supreme Court of Canada. For faculty members, also, how many publications do we produce per year, how much research funding do we pull in, and also, notably, the success of the law school's fundraising efforts. I would venture to say that many law school deans these days are less academic leaders than they are fundraisers. And I have to say, you know, often get asked, would you like to put your name in to be a dean somewhere? And I have to say, I've never said yes, partly because I loathe fundraising and I'm really bad at it. And I just know I would not be good at that sort of thing. But it does, tell you something about what the nature of being dean is. And I think that has changed quite radically over the last, 15 or so years. As well, as you would all know, and students in the audience will know, we've seen tuition fees rise exponentially at most Canadian law schools since the late 1990s, with the exception, I guess, of Quebec. Certainly, they're well over $10,000 a year at our school, and we have a tuition freeze in British Columbia, so that has hampered the ability of the law school to raise tuition, which they most certainly would do if allowed, because we do have a budget crunch. I believe I'm right in saying that the University of Toronto is $25,000 a year now. I think it's up in that range. So what impact does this commodification of legal education have on students, on courses, and professors? Well, donors to law schools, apropos of the fundraising initiatives that we have to do, are often, of course, major law firms. And I would like to be corrected on this, so perhaps in discussion you will, but I think it may be true that at least the major law firms that donate to my law school tend to favor more core or mainstream courses like corporate law and not necessarily things like feminism and law. So for example, when law firms hire, I know of course they're looking partly to grades that students have, but I think also often we'll have a look at the transcript and what types of courses, what range of courses students have taken. And I'm all for students having a broad-based legal education and getting a smattering of knowledge in a whole bunch of different areas. But if we also think that it's important for students to have some exposure to feminist and other critical perspectives on law, I think there are some deterrents out there to students actually signing up for those courses. It's really easy, I think, for students to feel pressured to take a mainstream path through law school, even if they are social justice minded. They fear not obtaining an articling position, and we know that there are very few articling positions in social justice or public interest fields. And of course, these days, they have a significant fear of not being able to pay back their student debt, which of course is increasing as tuition fees continue to rise. Even if they can get a position in public interest or social justice law, these positions tend not to pay as well as larger firms. So you can clearly see the incentives for students to compete for the bigger firm jobs. Also, major firms tend to, at least at my school, sponsor events for students at law school. And so they just simply have a bigger presence at the law school than public interest and social justice organizations, although we certainly try to bring those in as well. Our career services people do tend, I think, to lean somewhat more towards the large firms, and I do understand why they do it, but there's a certain skewing happening there. So this has a knock-on effect in terms of courses. Despite the fact that most law schools these days do now have courses on feminist legal theory and racism and law on their books, they are typically not prioritized for staffing nor offered every year. And even when they are, enrollment is not necessarily all that robust. Certainly a law student who wishes to avoid perspectives on law types of courses can do this with ease, unless something like a jurisprudence course is made mandatory. And even that course may not contain very much by way of feminist or other critical material. One Canadian study done by Natasha Bacht and a number of Canadian law school colleagues found that only about 7 to 8% of law students take a feminist law course. And some of the reasons students gave for not choosing those sorts of options was that they felt the market pressure. They felt they needed to take other, more core courses to market themselves for jobs. A second reason was that they didn't necessarily want their beliefs to be challenged, things like that, which is kind of interesting. I think that's why people should be in universities, to have some of our beliefs challenged. So I think that that study raised some questions about the extent to which feminism has been integrated into legal education. As for professors, the knock-on effect of low student enrollment in these courses is not only their cancellation on occasion, but also the fact that hiring of professors with feminist expertise is a low priority. There's one rather horrific story from a few years ago out of Australia, where a law school actually terminated the employment of 5 feminist and socio-legal scholars during a period of quote-unquote organizational change. Why were they terminated? Because they failed to meet the imperative of professional practice. Now, I've not heard of such extreme stories happening in Canada, I would like to reassure you, but I also would venture to say that neither have we entered an era when feminists can proudly advertise their feminist credentials to all prospective employers, whether these be law schools who are looking at them as potential professors or law firms. For example, candidates for professorial positions who focus more on core fields in their graduate work are more likely to be offered interviews, I think, than those who work more squarely within outsider fields such as feminist legal theory, lesbian legal studies, critical race theory, Aboriginal law, and so on. And so by now, some of you may be thinking, why do you think, Susan, it's so important to offer courses that focus on feminist analysis of law, rather than, say, focusing on making sure that at least some core courses are offered with some references to feminist inquiry on that field of law? So the reason I think is this: many of us go to law school with an often unconscious allegiance to liberalism, the dominant and therefore often unarticulated political philosophy in our society. And liberalism, for all of its virtues, does tend to assume that every one of us is on a level playing field, and it tends to obscure the ways in which power and disadvantage persist in our society, in our legal education, and in our profession. And not to ask hard questions about how to change that status quo. Now, even a course in feminist legal theory, one of which I happen to be teaching in January, can barely scratch the surface of this sort of taken for granted understanding. So expecting a nuanced analysis of that kind of type, critiquing liberalism, say, expecting that it will be taught in courses like, say, taxation or even family law, which I also teach, is, I think, unrealistic. As well, those professors who explicitly introduce feminist perspectives into their core courses almost inevitably encounter some resistance or even hostility from some law students. Now, I should say also, some law students are thrilled to see that type of inquiry, but having read many, many course evaluations over the years on my own teaching, I can tell you that there's probably more of the critique that says, why are we hearing all this stuff about, women and lesbians and gay men and so forth, even though certainly in a course like family law, I think you have to actually talk about gender and same-sex marriage and things like that have happened over the last few years. Also, if, like in my law school, core courses are often offered in multiple sections, and if the other professors who teach those courses do not introduce critical or feminist perspectives, the one professor, say, who does, is very easily cast as being biased or subjective in their course offerings, and that just has a knock-on effect in how students, I think, receive that knowledge. So that is, in a nutshell, why I think that we still need to, in addition to having feminists and other critical scholars teaching core courses, I think we still need to have those specialized courses like feminist legal theory, so that at least some students will have the opportunity to probe beneath the surface of our legal liberalism a little more carefully. So I'm conscious of time here. I have a few things that I'm not going to say, but if the conversation goes that way in discussion or in our workshops, I'd be happy to talk about it later, about the workload of feminist law professors. So that's less an issue, for students and for those of you in the profession thinking about what students learn in law school. But I think it is an issue of workplace environment for professors, so I can talk about that later. Just to wrap up, I do want to acknowledge that we've had important changes take place in legal education over the past several decades. Things have truly changed, but you know what they say, plus ça change. You know, changes don't always mean that everything gets better, right? We might have some things get better, some things get worse, and conditions change, including this corporatization idea that I alluded to. So despite space being made definitely for individuals who were previously excluded from legal education and from the legal profession, some serious challenges remain, making it essential, I would suggest, for a feminist and critical presence and voice and a commitment to social justice, and that these voices be central to legal education. I think we still have a lot of work to do to guarantee that legal education is a force for meaningful change and not a force just for preserving the status quo. And just as a kind of segue into my colleagues who are going to, I think, talk more about the profession, I think it's fair to say that because it is an entry point to the legal profession, getting a legal education is clearly a privilege in our society and in our university system. And so I think we do have a responsibility to provide students with a strong sense of public responsibility and commitment to social justice, which means a lot of different things. Because they are, most of them, going to end up being lawyers and have a really important responsibility to the public. Thank you very much, and I look forward to hearing what my colleagues have to say.
Thanks, Susan. I have to say, listening to Susan speak was like living my life over again. I started law school in 1974, not 1975, and I was here, not at McGill, but it certainly sounded familiar. So thanks a lot, Susan. And I now invite Tom Schonhofer to come and talk a bit about the changes in the legal profession from the point of view of the regulator.
Good afternoon, Justice Jackson, colleagues, and soon-to-be colleagues, I hope. Professor Wiegers was kind enough to describe this panel as brilliant, but I think if she was referring to me, she was probably describing my jacket and nothing more. My comments actually fit fairly well in with Professor Boyd. She talked about the corporatization of education. Well, I think what I'm going to talk about a little bit is how the regulator might work into that, what happens in the colleges in the future too, because I think education is a keen interest of ours now. So before I start, I think I better begin with the caveat that the views I'm about to express are my own and not official law society policy, but they're advanced to promote some discussion at this event. I have to admit that when I got a call from Professor Wiegers this summer inviting me to speak at this conference, and it's Achieving Equality, Emotional Well-Being, and Social Change Through Law, I said, you know, after 20 years around the Law Society, I said, well, what does this have to do with us? But never shying away from a challenge, I agreed to speak at this. And I asked the question because I think in many respects the regulator occupies a very narrow role in the legal industry. We really have very little influence about who is in the practice of law and how it's practiced in many respects. The regulator, in my view, is the keeper of the normative values of the profession, mostly enshrined in a code of conduct, and many of these ideas dating back to the last century. We promote civility, respect for the rule of law, high ethical standards, minimum competencies, et cetera, et cetera. And these values are all extremely important. I'm not diminishing them. In fact, when I see some of the political scandal we hear in the news these days. I think a law society and the legal profession could handle it much better than the Senate in terms of, what is ethical conduct and what isn't. But the normative values, as they are today in the profession, are heavily influenced by what I would call a lawyer-centric paradigm and a business-centric paradigm. So the regulator, like the Law Society, is basically a referee in this game, not really a player. Like a referee, we enforce the odd penalty and make someone sit out for a time. But I think the challenge for the regulator today, and this is where I'll be going for most of the talk, is that what would happen if the normative values governing the law societies and the legal professions changed? So what would happen if the law society adopted a consumer-centric value system? This is not an original idea of mine, because I see it happening all over the world. And really, we see it ourselves moving that direction more and more because of the access to legal services, access to justice debate that's been gaining some momentum. And this is not a recent phenomena. I recall back to 2006 in Saskatchewan, we had a panel here talking about it, and we started pro bono law in 2007. Justice McLaughlin made her famous comments at a pro bono conference in 2008. It's been going on, but it is gaining momentum. And most recently, in the past probably 3 months, we've had two very comprehensive reports. Michelle hopefully might talk about the CBA Futures Report, which we had in August. And just this past month, Justice Cromwell's Action Committee released its report. So the access debate forces us to ask, what would legal services look like if they were driven by consumer needs? So how are consumers, both big and small, influencing the legal industry? How does technology and globalization accelerate consumer choice? Sorry, I lost my place. Anyway, my view is that the changes we see occurring around the world will reshape the legal industry. And that will include education, it will include regulation, and it will include the practice of law or the service providers. So if I can make any contribution to this conference, it may be to talk about the future of the legal industry. What opportunities will the evolving profession have to achieve equality, emotional well-being, and social change through the law? So here are my thoughts. I'm going to pick on the college first, since that's where Susan left off. The regulator has the authority to control education and admissions, but historically has delegated much of that responsibility to the college. The Law Society requirements for admission as a student of law are simply that you have to have a common law degree from a Canadian law college. But the college recruitment criteria essentially determines who gets into the college, how many get into the college, the content of education, with a bit of a caveat now with the Federation getting involved, and who gets out of the college and hence into the profession. So the college is essentially a gatekeeper for the profession at the entry level. The product that it produces is a group of very bright, very well-educated students who know not a whole lot about the practice of law. And this system has worked remarkably well over the years in providing a constant supply of grist for the legal mill, but it hasn't exactly done a lot for access. So if, as a law society, we acknowledge that access to legal services is essential in a free and democratic society, and if the regulator's wouldn't we start at the beginning of the supply chain, which is the colleges? And we could ask questions about how many spaces are needed for training, what's the criteria for a successful lawyer, is the norm of a 4-year undergraduate degree required, is a 3-year legal education required, is articling required? What about tuition fees? As were mentioned, they're 2 to 5 times higher than the average. I have to tell you, I don't know the answers to these questions, and I'm not suggesting any answers to them. But I think they are fair questions if you start from the consumer perspective, and it's a discussion that will be had. Now, I don't think anybody expects students to emerge from the college as fast food. But I think the regulators will start asking the question, how does this fit into the access agenda? And before we leave education, I think there's one additional fairly recent development that probably most of you aren't aware of, and that's the recent and significant influx of foreign-trained lawyers. Now, some of these lawyers are Canadians going abroad for law school. Others have taken their legal education, are citizens, residents from abroad, whether it's Asia, Africa, Europe. We see them coming from all over these days. So the Federation of Law Societies, through the National Committee on Accreditation, has about 1,000 applications every year now. It makes the Federation the largest law college in Canada in terms of turning out people with qualifications for articling. And it's certainly had an effect in terms of providing an alternate entry point, and it certainly has an effect in providing a greater diversity within the legal profession. Going to move to part 2 of education, which is articling, and so we'll leave the colleges alone for a minute. As mentioned, the regulator probably has to look at phase 1 at the colleges, but in phase 2, the regulator delegates legal education to the industry, and frankly, with only very scant quality control. Good articles can be the most effective conclusion of a legal education. Poor articles contribute nothing to access by either poorly preparing lawyers or discouraging them completely from the practice of law. I think that Ontario is probably working on the answer right now, and it's through a practical legal training course, which is going to be an option, I think, starting next year, and they've got a 5-year pilot, but probably in Ontario, as in other places across the world, it will replace the formal articling program. And along with that, the Federation is now looking at national entry-level competence. And so what that tests is, after you get out of the college and after your year in the profession, whether it's articling or the practical legal training course, what are the entry-level competencies that every lawyer has to have? And I think that will probably be the driver of some type of a national exam in the end. So now to move on to the profession in itself, service providers. And I see 3 categories for the purpose of discussion. The first is, I'm going to call them corporate, and that includes all the in-house lawyers in business, municipalities, crowns, legal aid, government. Currently, that's about 1/3 of the practicing lawyers in Saskatchewan. The second category I want to discuss are what I call the retail service providers, and they provide a service to the general public. Now, it's hard to define what the size of this category is, but even if we start and look at firms of 7 lawyers and under in Saskatchewan, they essentially make up half the people in private practice. And one would think that there are firms with greater than 7 lawyers that still have a very significant retail service. So the retail segment is by far the largest segment in the province. And then the third category I want to talk about are the big firms that serve big clients. And this is even more difficult to try and estimate. There are 3 firms in Saskatchewan with over 60 lawyers, but they also tend to be full-service firms having some retail component as well. But that's certainly the smallest segment of the Saskatchewan profession. So if we start with the big firms, certainly for many that's still going to be the brass ring, serving the large commercial clients, and that's certainly where lawyers will have the greatest income potential. But I'm guessing that the growth of big firms may stagnate to some degree. And I think that's because there will be, first of all, more competition in the retail market. And so some of the big firms will shed their exposure to the retail market. I think that there will be a continued growth on the corporate side, on the in-house side, as we've actually seen for the last 15 years. In-house counsel will do some of the work formerly done outside and will also play a much greater role in managing the cost of outside counsel. And then there's also the potential of looking abroad for legal services. It's difficult to get any kind of an accurate estimate now, but you know, ranges from lows of tens of millions of dollars of legal work now flowing to places like India and South Africa. And so it's not that big firms won't continue to play an important part of the legal service industry. They provide very specialized advice in high-risk situations, and it's not that it's still not a very viable career alternative, but the opportunities, I think, will decline relative to other sectors. In terms of the regulator will only have minimal involvement in this sector because this is not a place where access is an issue. The people who go to these firms can afford the services they're consuming. So if we move to the second branch, the corporate sector, which is, as I say, currently about 35%, it'll continue with steady growth and become a larger portion of the membership. So our statistics show this is happening and continues to happen. And corporate growth has, I think, demonstrated a benefit of developing specialized in-house counsel and providing predictable and controllable costs for those it serves. For the lawyers and paralegals working in the corporate sector, it'll provide a more balanced working conditions, including more predictable hours, predictable remuneration, pensions and benefits, leaves, that type of thing. So that section of opportunities for the legal profession will grow. And interestingly today we see as a trend both men and women leaving private practice in fairly equal numbers heading to the corporate sector. Once again, the regulator will have little involvement in this sector because it's not an access issue. So the retail sector is where the real revolution might occur. And as mentioned, this is the biggest area for service providers in Saskatchewan. And here's where the regulator gets involved. And I think we have to start this conversation with who can deliver legal services. Sections 30 to 32 of the Legal Professions Act currently give a monopoly of legal services to lawyers. And the question is, should we push some of these services down to lower-cost providers such as paralegals? Which services, how much protection does the public need? Should the market decide? These are all questions I think we have to debate. We've talked about traditional legal education, and personally I'm a supporter of the value of a liberal arts education, and I support much of the way which law is taught. But for many legal services, something far less would be adequate. One may not want one's judge studying an issue with a lot of social policy, or one's lawyer not to have a very traditional legal education. But a lot of what lawyers do in their day-to-day work could probably be done by somebody with significantly fewer qualifications. So every legal regulator across the country now is looking at paralegals, whether they're licensed and independent, whether they're under a lawyer's supervision, what services they can provide. And I think that this is going to be a second stream of legal service providers in Saskatchewan fairly soon. Second issue, should services be provided by other than lawyers? And the term that's often used is ABS, or alternate business structures. Today, in Britain, for example, the co-op there has 4,000 branches. You can go to the co-op and you can buy your groceries. You can arrange your funeral if you like. You can get financial services, and you can get legal services at a fixed fee. So the question is, are there other non-lawyer owned business models that provide better consumer service? Fred Heaton, from the National CBA president, and Michelle's probably heard this speech more than a couple of times, but Fred is a in-house counsel at Air Canada, and he tells a great story because he talks about Air Canada operating hundreds of flights per day around the world, and how complex it all is. All the planes and crews have to be in the same place at the right place at the right time. The weather has to cooperate. There are mechanical issues, regulatory issues, and Fred goes on and on about all the things that have to take place for every single flight to get off the ground. And then he has to go to his vice president of legal and explain why you can't get any kind of a quote on some simple litigation in terms of having a fairly fixed fee. And so, and he uses the example. Imagine if Air Canada said your flight to Toronto is $500, but oh, by the way, if there's a headwind and we burn more fuel, or if we have to circle around Pearson for half an hour before we can land, the cost of your flight's going to go up. So Air Canada can do that because they work on volume and they've got a system, and that's how the co-op in Britain does it too. They've got a designed system for legal services. They invest in technology. They're able to break down the services into components, and then they have the volume, which gives them a predictive capacity. So most regulators are now actively looking at the regulation of business entities. So the amendments to the Legal Professions Act, which are currently before the legislator in Saskatchewan now, will allow for the Law Society to regulate a business entity. I guess the hope is that some deregulation of legal services will allow for some innovation in the delivery of legal services. So if I circle back to where I started, which is what's the likely impact of the changes of delivery of legal services, I think it's easy. We have to rethink legal education to some point, and that's at the colleges. It's perhaps at the community colleges. It's at the bar course, and perhaps in the firms. I see an increasing number of individual legal service providers, and I use that term because I think we have to think about lawyers and paralegals. But there are increasing numbers of law schools now. We have Lakehead and Thompson Rivers come online recently. McGill has a common law program now. I hope nobody asks me about Trinity. But once again, another source of potential law students. We have increasing enrollments in law schools. I know Queens was floating their balloon not long ago about how many students they might take in. I think we have paralegals coming into the stream, which is inevitable, and the foreign applicants will continue and perhaps increase. So a greater number of people participating in delivery of legal services. And what's the result of this? Well, hopefully some more consumer choice, perhaps some more competition in the market, perhaps some innovation, perhaps some unemployment. I see an increase in the corporate sector and the opportunities that provides to the legal world and lawyers. I see business entities other than traditional firms playing a larger role in the market. And let's talk about the co-ops. One of the big issues now is delivery of services in rural areas in Saskatchewan. Why wouldn't the co-ops in Saskatchewan be an ideal vehicle for providing services when they have branches all over the place? In any event, if these things come to pass, that would once again provide other opportunities for lawyers outside the normal practice in firms. So it's perhaps a brave new future. In the next 10 years, we'll look forward to seeing how much of these predictions come to pass. Thank you.
Well, it sounds like one of the career opportunities you might want to consider is working for the Law Society. Sounds like they're going to have plenty to do over the next little while. Michelle, would you like to come and take the microphone?
Thanks very much, Beth. So I'm going to speak briefly about private practice and women in private practice, and more specifically, some emerging trends in private practice and how those may affect women. My comments are not directed to or focused on public sector or government or in-house or male lawyers, because I have never been any of those things. But I will try, where it's appropriate, to try and extrapolate a bit. But I certainly invite you, because we're trying to save plenty of time for discussion and questions, to please take notes and chime in, because I've done a lot of reading in preparation for this, but largely these are just my own thoughts on some of the material that I have come across. I want to begin with a brief sort of State of the Union, as has been said and I think is recognized widely. The number of female students articling, law students, articling students and associates has been at critical mass for a long, long time now. But the number of female partners, particularly the number of female partners in management of firms, the number of female judges in many jurisdictions at different levels of court, and the number of female executives, presidents, and CEOs of corporations where they have started in the legal departments do not reflect the numbers of women who have entered the profession. And I'm not talking about just the recent. I mean, you know, we've had women in these numbers for 20 or 30 years now, and we're not seeing those women at the upper echelons, and I'll talk about that in a second. Disproportionately, women leave private practice, and they may go elsewhere, or they may leave practice altogether. But I think it's an inescapable truth that women disproportionately leave practice. I want to be very careful here on a couple of things. First of all, I am not of the view that being the managing partner of a large national firm is the definition of success, much less the only definition of success. I think that part of this discussion at a very personal level has to be about how you define success for yourself. And I also think, of course, that this is a discussion to some extent about choices. And it cannot be, it is not, I would never say it is, I hope no one would, that it is inherently wrong or bad to make a choice to leave private practice to do anything else, whether that's to take another job or raise a family or whatever it is. But this is about choices, and I think the quantitative and qualitative truth is that women are in a position where sometimes they don't have choices. The numbers would tell us that this isn't just a matter of personal choice, that women are often left with seeing no viable option for them to stay in practice, and that's what I want to talk a bit about. So the trends, and Tom was right, I will be taking some of this from the work of the Futures Committee of the CBA. The trends that I want to talk about briefly are different billing arrangements, specialization in practice, part-time work, and then a formalized approach to diversity and inclusion. So, different billing arrangements. I've been saying for 20 years that an hours-based billing arrangement doesn't make any sense. And I've done nothing about it but talk about it for 20 years. So I am as guilty as anyone of perpetrating the model that many of us think is not the best. From a lawyer's perspective, it's not best because, frankly, you're selling your time for money. And so you are always going to be limited, even if financial is your only interest. You know, unlike a celebrity who can sell one performance to millions and millions and millions of people at one time, we can only sell an hour of our time to one client at a time. And so we are starting out with a very limiting proposition. That, of course, means that external circumstances that take away from your time, however it is that you chose those circumstances or didn't, are going to impede your ability because you have less time to sell. It is not a system, I think, that it seems to me to be self-apparent, that frankly rewards efficiency or innovation. You know, the more hours it takes you to complete something within the client's expectations, the more your reward is for that. And that's just not a model that ever made any sense to me, not from a consumer perspective, and I think that's what Tom was getting at. Certainly, I will tell you that is what the Futures Committee is hearing, is that we are inevitably going to see client-driven change at this point. And I hear from a lot of my in-house counsel friends, we're not going to do this anymore. You know, if I had a plumber come to my house, which happens a lot, and I said, how much is it going to cost me to fix that sink? And he said, well, it's $85 an hour. I would say that's not what I asked you, and that's not an answer to my question. So, you know, I wouldn't accept that from someone. So how can I expect that my clients are going to be satisfied with me saying, well, I'm going to charge you X dollars an hour? And, you know, I don't really have any idea how long it will take, but just trust me and hang in there, and, you know, you'll get a bill every month. You know, that's not a satisfactory answer, I don't think, from a client's perspective. So as we move to these models, and I think it will happen, the point that I wanted to make is, this is a generalization. The women that I know are pretty good multitaskers. And so, and it's not restricted to women, but if you are in a situation where you are holding down more than one job, you are, you know, raising kids and you have a job, you are traveling and you have a job, you are doing a bunch of volunteer work and you're combining that with a job. The women that I know are doing a dozen things all the time at the same time. And I think that that sort of skill set will actually lend itself very well to innovating some of these new billing arrangements that we may be forced into anyway. A system that rewards me for thinking innovatively, getting right to what it is that the client wants, instead of less about, you know, what I know or about winning, but actually says, what is it the client really wants out of this? And how am I going to get that the most effectively? And how do I take my knowledge and replicate it in a way that allows me to essentially sell the same product, if you will, to a number of clients without having to start over again. Those are the kinds of things that I think are going to happen. On the issue of specialization in private practice, and again, people think that this is a big firm phenomenon, and I think it may be, but I can tell you even at my firm, which would be considered a small firm in Calgary, there's no question that we are becoming increasingly specialized. One reason for that, of course, is again related to the hourly rates. At what I charge per hour, no one is going to pay that to have me learn about immigration or you know, insurance defense work, which I don't do. So I have to make a choice about whether it's an area that I am sufficiently interested in to spend my own time, and unless it is, my time is better spent becoming and maintaining my expertise in the areas that I've chosen. I think this may or may not be an advantage for women, but I think that there's something reassuring, and certainly the lawyers, male and female, that I practice with find it so, that you don't have to know everything. So I'm talking now about some years into practice, but that you can take an area, 2 areas, 3 areas, really focus on them, create and maintain your expertise, which takes, not as much time once you're established in that area. I also think, though, that we are going to see more and more specialists by area outside of the firms. I think that we're going to see more and more consulting type arrangements. I think that, someone like myself that has an expertise of sorts in employment law, for example, I love my firm, but I could go out on my own and I could provide that expertise to a number of firms at one time. And I think that as firms find it uneconomical to take on a lawyer with immigration expertise who only does immigration because they may not be able to support a full practice, that lawyer with that expertise could become a very valuable commodity to outsource some of that work. And in fact, we see outsourcing, of course, growing in use in areas like research and document review. Why not in substantive areas as well? So that's one thing that I think may create some niche practice areas. I also want to talk a little bit about part-time work. And this is, I know, a bit of a touchy subject. Some people, I think, have tried part-time practice and have been very happy with it and found it it met their needs. But we also know, and the study from last year here in Saskatchewan had a lot of quantitative and qualitative information about part-time arrangements that didn't work for women. And I think this is my own view on this, that it's very difficult in our profession to say that part-time is going to be X number of days a week, that it's going to be 3 days or 4 days a week. And what you consistently hear from women who try to arrange a 3-day-a-week or a 4-day-a-week arrangement with their firms is that, of course, their practice isn't restricted to 3 days a week. It inevitably spills over into weekends and evenings and so forth. And, of course, I sort of say, well, that's because the premise is flawed. I mean, you're starting with assuming that a regular full-time practice, I guess, which is what I have, is 5 days a week or 40 hours a week. It's not. It's sometimes 2 days a week, and it's sometimes 7 days a week. And it just depends on what it is I'm doing and who I'm doing it for and how much work I've taken on. So what we've done in our firm, and this is only with one of our associates, but it's working really, really well, is to simply say that this is the number of hours you need to get for the year. And however it is that you choose to do it is how you choose to do it. That, of course, translates to how much receipts. And again, if you go back to the idea of alternative billing arrangements, it gets even more flexible, because if we say what you have to do is bring in X number of dollars at the end of the year, and how you do that and how many hours you work and when you work them is all up to you. I think that is a better approach to the kind of flexibility that people, particularly, I mean, this woman that we have in our firm is a young mother with preschool age children. So it works very well for her. If the kids are sick, she just stays home. She doesn't have to take extra days. If she's really busy, then she comes in and she works it out. And when she can take extra time, she does that. And she's never had any trouble in meeting her expectations. I think it's very important to recognize that women that opt for part-time arrangements, whatever it looks like, still need the support of the firm. And what I do hear from a lot of women who opt to go part-time is that they don't feel supported by their firms. They feel ostracized, they feel marginalized, they don't get the work that they need. I think it's really important, if a firm is going to offer something like that it's not in name only, that they provide those women with mentors, with sponsors, with that sort of extracurricular support, if you will. It is equally important that people who opt for those kinds of arrangements understand that there are still those kinds of extracurricular expectations of them. In other words, to the extent that all of us are out there going to things, and we're bringing in business, and we're volunteering on committees, and we're mentoring other students, that if you are part-time, there is still going to be some expectation, and it's to your benefit to stay plugged into the firm and plugged into your legal community. The last area that I wanted to touch on is this idea of formalized diversity and inclusion, and this is an area that I've been reading a lot about and am quite interested in. And actually, at the National Conference of the CBA, heard Dr. Aaron Reeves speak about this, and so what I'm saying is a lot of parroting what I've been hearing. Diversity is more a discussion about who is in the firm, and inclusion is a discussion about how you have integrated those people. So her theory was you cannot have one without the other. You can go out and hire as many diverse people as you want, but if you don't include them, they will not flourish, and you are not getting the benefit of what you have done to create or to recognize the need for that kind of diversity. It is really, it looks to me as though, frankly, it will be the corporate culture that leads this movement to diversity and inclusion in large part. There's talk in law firms about how corporate clients, and certainly I think this is true, we do a lot of work with the American Bar Association, and they have very interesting expectations. Their in-house counsel of big corporate clients are basically adopting very formal measures of what is required in the service provider in terms of diversity of a legal team that will do the work. And if you don't have it, they won't give you the work. And so again, you can see it is to some extent a client-driven change, which is fine. I don't care how it happens. I'm kind of excited about the idea that whether it's client-driven or not, that we might be forced into a position where, you know, you need to do this in your firm. You need to have certain numbers of people who reflect not just society, but what is increasingly a heterogeneous client base. Big firms in the States and big firms in Canada are for example, appointing diversity officers. Most big companies have what they call diversity officers. There is discussion about making corporate boards, making it mandatory for corporate boards to have a certain number of women on their board to qualify for registration at a public exchange. I know that these ideas of quotas, affirmative action, I know that those are highly politicized and very controversial, and that's, but I also believe really strongly that numbers matter. I don't think it is the same thing to have a law firm with 2 women out of 40 that it is to have a law firm with 20 women out of 40. They're different. The firm that I am at now, I've been there just over 12 years, has always had as many or more women than men. It's been about equally split. And importantly, there's always been as many women in management, as many women in the power roles, I'll call them, on the compensation committees, on the points committees, the rainmakers. Those have always included women in equal numbers. And, it's very interesting. I don't think in 12 years I have ever felt that whatever my other challenges were, that there was any, at least internally, any issue, that any opportunities that I was given or weren't given were related to my gender. I'll give you an anecdote here of one of my partners, Wendy, who, when she was starting, her son Scott was just a little guy, and Wendy was an up-and-coming female lawyer in Calgary at a time when there were not a ton of women in that position, and so her social group was the other women who were also in private practice, and they socialized and were very close. And so Scott's exposure to the law was always through his mother and his mother's female friends. And so one day a very well-meaning family friend asked Scott if he was going to be a lawyer when he grew up. And he said very disdainfully, "No, only girls are lawyers." So I tell that story because my environment where I am now is really, I think, rather unique. And I don't think it's a coincidence that women that women have had an equal say in that environment, in how that firm is managed and the directions and the culture and everything about it. I think that it's important to, this idea that there aren't qualified women who apply for directorships. There aren't qualified women who apply for managing partner positions. There aren't qualified women applying for the bench, which is what we've heard. I don't believe that. I don't. And if it is true by number, then we need to do a better job of providing leadership training, of providing the support and encouragement and grooming for people to make viable choices to stay in the profession and to achieve those kinds of things. I think that we need a more structured process for women to identify and train women for leadership roles. And I believe that, we have confident, competent, engaged, and supported women. And if we can get them through the system, whether it's a combination of all these things or something else altogether, then I would like to believe that, that there will be appreciable difference.
Thanks, Michelle. Our last speaker is Catherine Hensel, and she's going to talk a bit about advocacy for Aboriginal clients.
Wrestle with the mic for a second. Catherine Hensel Insquest. Good afternoon, everyone. My name is Catherine Hensel. I greeted you in my own language. I'm Shekwetmik. That was Shekwetmik Sheen. I'd like to thank the organizers for inviting me here today. It's wonderful to see you all. Thank, of course, the people of Treaty Number 6 for hosting this gathering, the University of Saskatchewan, and greetings to all of you, and particularly Justice Jackson. I wanted to talk a little bit about my own professional background before I got into the meat of my comments. I'm primarily and pretty much exclusively a litigator. I have been for 10 years now, or arguably all my life. It's my temperament, and it's and I decided when I was 17 years old that I wanted to be a lawyer, and I was working in a law office. I was a high school dropout at the time. I was working in a law office, and I immediately felt tremendous affinity for the lawyers that I saw. Not all the lawyers, obviously, but I'm tremendously grateful to be a lawyer, to be able to practice, to be amongst lawyers. I have such affection and respect for the practice of law, for the profession, and for many, many, many lawyers, not all lawyers. But, so that's where I'm speaking from. Obviously, I have affinity for my own people, for other Indigenous people. And so I'm going to talk a little bit about my experience as an Indigenous woman, a litigator, and there's very few of us in the country, like less than maybe 5, and not many more litigators, Indigenous litigators, amongst the men. And I'm not gonna spend a lot of time talking about the experiences which are quite regular with other members of the profession and with some, regrettably, some judges who find it, who see me as an Indigenous person and note that I appear to be a lawyer and comporting myself as a lawyer, and their reaction just, sometimes it's expressed and sometimes it's implied, but really suggests strongly that I shouldn't occur in nature and that I'm not something that actually exists. And then after I've worked with them for a while and been in front of them, then I kind of win them over and convince them that I do exist and that and others like me exist, and that I'm and then I am almost, and then often the response is, or the commentary is that words to the effect that I am a credit to my people, which I'll take. But these responses are so, frankly, absurd that as a parent of young children, I find it's best to ignore bad and stupid behavior. And also I have the luxury of doing that because of my predecessors at the Indigenous bar and within the, women in the profession as well. So I can stride confidently and unapologetically forth in the profession and as a litigator, and not necessarily safely, but functionally ignore that kind of response, and it falls away. And that's not my doing. It's the people that came before me, and it's the profession itself that has opened up and educated itself about inequity. But I'm going to focus a little bit more on the substantive impact of the obstacles that we're talking about, particularly when I advocate, and my firm does exclusively on behalf of Indigenous people and organizations and communities. And I'm going to tell you a story of something that happened last year, just as a paradigmatic. I was representing an Algonquin nation in the eastern part of the country. Several of their members had stood in front of forestry equipment and prevented logging and forestry operations. The forestry operations themselves had destroyed numerous sacred sites. There was no consultation going on. There was no accommodation going on. There was no regard for the destruction that was happening on the ground. There was no attempt to mitigate the impact of the harm that was happening. So several community members had taken it upon themselves to interfere with logging operations, and the forestry company had, predictably, sought an injunction, interlocutory and a permanent injunction, preventing those individuals and James and John's Doe from doing that in the future. I was retained by the First Nation itself because the individual members had raised title in their own defense and made a claim for title, and of course that's a collective interest, and so the nation itself got involved, including the individual band, but also the broader Algonquin Nation. So we had agreed in the course of the procedural to and fro to a brief adjournment, 2 or 3 weeks, to get some affidavits filed to make things happen on the evidentiary front. We had an undertaking from the lawyer for the forestry company that no further logging activity would be happening in the interim, and we were, of course, seeking injunctive relief by this point ourselves, or on behalf of the clients. And the morning of court, the clients came to me and my associate literally weeping. They had pictures of logging roads that had gone in during that 2-week period they had pictures, they looked like moonscapes. The corridors were so wide, the trees were it was 80-foot wide flattening directly through an incredibly sensitive site, both for its spiritual purpose, and these are, the members of this community are, they are very traditional people, intensive traditional users of the land, still live a traditional life. Most of the dealings I've had with them, they deal with each other in the Algonquin language, and they have a very good, they have an intimate and direct engagement with their land, socially, economically, culturally, and spiritually, and live on the land. So this was devastating for them, and they were distraught. I have some experience of the kind of despair, personal experience with the kind of despair and the impact that this would have had on my clients. Just my own people have had rock faces that embody both our spiritual, historic, scientific, and cultural life blown to pieces, literally, to make way for roads. And so I could begin to appreciate for the Algonquin people the effect that had on their hearts, what had been lost forever, how they'd been diminished as a people, what they couldn't pass on, now pass on to their children, and their own sense that they had failed to meet their obligations. And I had a strong sense as a professional that that had happened under our watch in that 2-week period because of an adjournment that we'd recommended and sought. So that's the sort of context going into court today, or that day. And I was engaged with, outside the courtroom, as one does, with the litigator, you know, good, very skilled litigator from one of the top-tier national firms, outside the courtroom to try and talk to him about, well, is there any way to resolve this? Because my clients weren't saying no logging, they were just saying, don't do this in these places. You know, go around. There's places that aren't as sensitive. There's places that we could arguably afford to lose if we can just map them out. They were seeking that kind of dialogue and engagement. But I said, what you need to know is what happened over this 2-week period was both from our perspective of breach of the undertaking, but more importantly, it was devastating. It was devastating. That's what we're trying to avoid. That they're, you know, they came to us weeping this morning. And he looked at me, he turned to me and he looked and he said, wow, you've really drank the Kool-Aid, haven't you? And I stopped, and I wasn't watching my own face, but I assume I gave him what one of my cousins affectionately calls the Bowie family stink eye. Like I said, this conversation is over, and turned on my heel. I couldn't continue to talk to him in that moment, and I had to take some time to understand for myself why I had such a strong and very angry response. And despite the fact I'm a litigator, when I become very, very angry, what I do is I stop talking. I've given, unfortunately, some judges that same stink eye. It makes them very uncomfortable when you stand at the podium for 30 seconds, which is a long time for nobody to be talking when they've made me so angry, and just glare at them. And they've told me afterwards that it's quite frightening. But I didn't bother sticking around for this guy. But and he did, to be fair, he did come to apologize because he understood that he'd breached something with me, and he thought he was talking to me lawyer to lawyer. And that, having had now almost a year to really unpack it for myself, was the most disturbing part of it. He appeared to expect that as a professional, as a lawyer, that if I was going to convey my client's perspective, that I was going to do it with, and be a reasonable lawyer, and professional lawyer, I was going to do it with a deep degree of skepticism and disbelief, or perhaps even contempt for what my client had expressed to me. Perhaps he thought, and certainly these are the submissions that and the motives that were attributed to the client by the forestry company and during the litigation, that the interference with logging operations was for money, out of a sense of belligerence, or some kind of inchoate but irrepressible tendency towards just mischief because of marginalization or something. And that was just not the case. These were principled people. They were citizens of their own nation, trying to fulfill their own responsibilities and permit their people to continue to exist as a people. And they were devastated personally in a very intimate way by what had happened on the ground. And I haven't had the privilege of having the same relationship with my language, my culture, my land, the same intimate connection. But I know enough to hear it and to see it and to be able to understand the client, not understand the client necessarily, but to listen to the client when they, and I view it as essential in my advocacy on behalf of the client that is what I communicate, that I don't diminish the importance of it, that I don't try and morph it into some other set of cultural reference points and values that is not Algonquin, but that is, will match point by point the objectives of a corporate entity such as the forestry company. So, and that experience was in the midst of, during last year, I represented within a 14-month period Attawapiskat First Nation. I represented Chief Teresa Spence during the, I was her legal advisor during her hunger strike. I was counsel for the people of Lake St. Martin First Nation, who are still languishing in downtown Winnipeg and dying, and as well as this First Nation. And these cases are really crucibles. And as a professional, you're laying across the crucible, and they can actually, I felt at various points last year, destroy you, notwithstanding my tremendous love of the practice of law. So I'm very much looking forward to actually the session tomorrow morning about emotional well-being, and because I'm dealing with it these days primarily through burnout measures. But so coming into my practice, the practice that I have now, I was with McCarthy Tetro for several years as a student, then as a litigator, then I was commission counsel at Ipperwash for a bit, and then I went back to Bay Street. But before that, I graduated from U of T in 2002, and U of T presented itself to me as always a center for excellence. They use the word, and I love the school, I teach at the school, I spend a lot of time at the school, but it's the excellentest place of excellence in the whole excellent world. So that's, that was my experience, and very much transmitted, these are establishment values. What we are teaching you is at the core, it's, you don't have to question it, because it's excellent, right? And the people who taught me there, I had Professor Kent Roach teaching me criminal and some constitutional law, and he's one of the main authors of the Aboriginal Legal Services Factum that formed the Supreme Court, that was directly lifted into the Supreme Court of Canada decision in Gladue, and he's done a tremendous amount of other litigation, and worked into his criminal law course, Royal Commission on Aboriginal People, Manitoba Justice Inquiry, as well as the considerations that had arisen in Gladue. I had Professor John Burrows, who Nishnabek man from Cape Croker, who is one of the preeminent Indigenous legal scholars, who is a proponent for Indigenous law already being part of the Canadian legal paradigm. It's just unrecognized, but it's there already, and it just needs to be given life to. Professor Darlene Johnston, who became a very good friend of mine, who writes poetically and beautifully and advocates for representations with integrity of the Anishinaabeg perspective on Dodemic law, treaties. These people, to me, and the knowledge they imparted, were presented as part of not black letter law, but not particularly controversial law. And it's not as if RCAP or Manitoba Justice Inquiry is controversial. And so the normative values that were transmitted to me gave me a very firm foundation, along with contracts, property, various versions of property law, tort law, and everything else I learned. They were embedded directly into the body of knowledge that I was immersed in. And so I didn't have to be, despite my temperament and subclinical, I say, oppositional defiant disorder, I didn't have to be skeptical of everything I heard, because this because this knowledge and these words were already in what was being taught to me, and it was transformative for me, beyond the normal transformation that law students undergo before they get, as they come to the click and become capable of true legal analysis. So I'd encourage, and in the discussions we have today and tomorrow, that more thought be given to how to ensure, and UBC has a tremendous initiative in making at least Section 35 and Canadian law as it applies to Aboriginal people part of the core and required course developments. And the legal profession and law schools can't correct the lack of knowledge on the part of Canadians about Indigenous people, who we were, who we are, and what our relationship is with the Canadian state. By the time you get to law school, you've had, 25, 30, however many years of education, personally, from your family, from your parents, your community, and through the school system and undergraduate years. But the result of it that I see when I'm treated like I've got horns and a tail, when I reflect in court, both the perspective, the honestly held perspective of my clients, and what I was taught at U of T, suggests to me a real lack of capacity on the part of both the profession and, unfortunately, the courts to fairly advocate for and adjudicate disputes involving Indigenous people. That is something that I can't accept, and I don't think the profession and the courts want to accept, because you've heard how I feel and my perception of the legal profession, and I'm a litigator, so this is my life. So I can only note to you that it causes tremendous harm to the law as we go forward, this lack of capacity and insight and ability to hear. And in doing so, the fiat justea, I believe that. I believe this school wants that. I believe every school that I've been to wants that, and the profession wants that. The courts want it. The profession wants it. So if we're going to be capable of delivering justice that has integrity and that's effective and that has a quality that makes it durable for maintaining and enhancing the tremendous things that Canada has been able to accomplish as a society and as a state, and extend them to Indigenous people, because they're not. These tremendous things are not enjoyed by Indigenous people in this country, then I think the profession and law schools really have to expand and embrace some of the issues and topics I talked about. Thanks.
Thank you, Catherine. I'm sure you'll agree that this panel has given you a lot to think about in terms of the challenges facing the legal profession and legal education in accommodating the interests of women, of consumers, of Indigenous people, and of other parts of Canadian society. Over the next certainly for the rest of this afternoon, you'll have an opportunity to chew on some of these issues in your small group discussions, and you'll have a chance to buttonhole the speakers at a later time. But we do have a bit of time for questions or comments if anyone would like to ask those now. Oh, you're just like law students. Sylvia. Hi.
The gentleman here, I would like to, it's more a statement than anything, but I did do a little bit of research on the Senate, and you mentioned that you would look towards the lawyers, that they would be more ethical or something like that in that kind of area. I would like to say that I think half or more of the Senate do have law degrees. So that's food for thought for everyone else here. And I would like to say thank you for all of you, your information. I also like to say that land is totally tied to education. And part of that, I think, is decolonizing and indigenizing a lot of the information. That involves law. Law has become quite a weapon. And that's from my experience from traveling and being out in the communities. So just a statement. Thank you.
Thanks, Sylvia.
Don't make us get Socratic on you.
Yes, that's right. We'll ask them questions. Oh, sure. Hi.
I have a question with respect to corporatization. I'm a member of the University Senate here at the University of Saskatchewan, and we've raised that issue at Senate meetings. And I have a question with regard to the law school, because I remember reading years ago, an esteemed professor, I don't remember which one, wrote an article suggesting that lawyers will become more numerous because more law schools will expand or increase, because that's one of the most commercially viable options for a university, because there's very little capital costs to educating a lawyer other than the library maybe. And so I'm wondering how that, if anyone could comment on that, if that ties into the corporatization issue.
Would you like to comment on that, Susan? You
Yes,
were the
that's
one who
me.
was talking about
But other people
universities,
might have
right?
thoughts.
Yeah.
I'm just trying to think that one through, because I alluded to budget problems at my own school, although, you know, we also just got a brand-new, beautiful building, and lots of fundraising, you know, contributed to that. So that's kind of corporatization, but we benefit from it and so on. In terms of the cost of a legal education, I mean, it's true in contrast, say, to some of the sciences or medicine. We don't need laboratories, we don't need equipment and stuff like that. So I guess those costs are not there. The main costs are people, frankly. So it is the people who are teaching in the classroom, our support staff, and so on. So I don't know, I'm not quite sure how to translate that through into corporatization. What, for example, one of the things that would concern me is if, you know, we had to go down the road more of having sponsored professorships. So say a named professorship in something like corporate law or whatever it might be, tax law. And if the donors to that position wanted to have some kind of say in who was appointed. And that has happened at some universities. And universities have tried, I think, to protect against that notion that if you are the donor, you get to dictate what type of person or precisely who is going to be in there. And because it's an academic freedom kind of issue. So anyway, but I mean, it does occur to me that some aspects of legal education are costly, and one of them is clinical legal education. So at my law school right now, we mostly just have our Indigenous Law Clinic, which is really, I think, quite a success story, but we only have the capacity to have, I think it's 10 students per term. So that's not very many students out of our whole student body, right? Our entry class is something like 150. And if we would want to offer more clinical programs that give students both the opportunity to take some of their knowledge and develop their skills and give back to a particular community through clinical law, then that would definitely take more money, I think, than we currently have the budget to offer. So I don't know. I'm not sure I understand precisely where you're going with that, but those are some of the things that arose in my mind.
I think in relation to the part of your question about the number of law students, I think the number of law students in Canada has remained remarkably stable for a long, long time, until recently. And Tom mentioned, you know, that a couple of Ontario law schools have expanded their intake in first year, and there are, for the first time in a long time, several new law schools, which we'll have new graduates. And I'm not sure we can foresee what the impact of that will be, because this is a relatively recent development.
Can I add something?
Sure.
What you've just said, Beth, reminds me, in the United States, where opportunities in the legal profession have been numerically plummeting, partly because of the economic crisis and so on, apparently law schools in the United States are finding their applicant numbers, so students are not, they're way down, so students are not applying to American law schools in the way that they have in the past. And of course, they have a gazillion law schools, so it's a different kind of scenario there, to the effect that a lot of American law schools are right now essentially trying to downsize their teaching staff, their professoriate. And in fact, we're seeing more American law professors apply for jobs in Canada right now because they're so nervous about the opportunities. So that's just a kind of interesting link between the economy, opportunities in the profession, right, and what's starting to happen there in law schools, and where that's going to go, who knows?
Right.
I don't know.
Okay, well, I think I'll ask Wanda to come and give you your marching orders for the next phase, but on your behalf, I would like to thank the members of our panel for getting us off to a stimulating start. Thanks.